drafting principles and guidelines as refined by the Constitution and other legislation that supports the public policy that has been introduced by the Constitution. So that's the first part that I believe we should focus on today, and I've prepared slides for that. Tomorrow, I'm hoping to finalize those guidelines and deal with the actual drafting techniques of some of the more common contracts that we encounter in our daily lives, like sale, lease, like credit agreements, and even employment agreements. If we can go through those and deal with them with some of the drafting techniques and the requirements, the necessary terms in those contracts, I will feel we've done well for a second day. And the third day on Wednesday, I'm hoping to look at the more challenging contracts like construction contracts, shareholders agreements, and perhaps even the purchase and sale of shares. That is what I have planned. And before I start, let's just go through some of the ground rules that we had decided on the first time we were together. I thought we had agreed on a break halfway through the session. Am I correct? A 10-minute break halfway through the session. If that is not correct, please let somebody correct me. We had agreed on that. We had agreed also on muting ourselves for as long as you're not on the floor, you're not talking. Please mute yourself so that whatever is happening in the background where you are does not disturb or cause an undue disturbance to the session. We also agreed it's even anybody who wants to say something, they just put up their hand. And we also agreed, the fourth agreement was that where I miss the hands, because I'm not always on the Teams screen. I'm a lot of the time on the presentation screen. So where I miss a hand, please let somebody tell me. I think that there's a fifth agreement which was to the effect that let there be someone also who watches the hands, who put up their hand first and who came second, who came third, you know, that kind of thing, so that we are fair. We don't make people put up their hands and then wait forever before they can pose their question. Do you want to allocate duties to specific? Like who will assist me to watch out for the hands, and who will assist me, and that person, the very same person, should also assist me to watch out whose hand was first and whose hand was second. There is a hand, somebody, Huiti. I don't know if I'm pronouncing the name correctly.
Good evening, Judge.
Evening.
We also agreed on asking questions at the end. Like you just carry on with the work and then we jot down the questions that we have. And then we ask the questions at the end in order to prevent disrupting the class.
Okay, correct.
Yes.
Very correct. Thank you so much.
Thank you.
Thank you very much. We agreed on that as well.
Sorry,
So
Judge,
all-
there's a hand by Sandile. He was actually first.
I can't see Sandile. Okay, Sandile, please go ahead. Sandile, you're on the floor.
Okay, ma'am, no thanks. I'm sorry, I wasn't aware that I've raised my hand. Sorry.
Oh, you were not, it was unintentional. Okay.
Yes.
All right. Okay. I asked a question though. And the question was, is there somebody that can volunteer to assist me to watch the hands and also to assist me to check whose hand came up first? Lebo? Lebo, do you volunteer? Or are you volunteering somebody?
So, sorry, Judge, I assisted you the last time.
I'm sorry, I wanted to find out if from your side the hands are not listed.
When I'm on the presentation screen, I don't see the hands. I
Oh,
see the
okay.
hands when I'm on the Teams screen.
Oh, okay.
That is why.
All right.
Judge,
Lebo?
can I nominate Adam Sibia? I think he's the one that assisted you the last time. And in terms of the time for a break, I think can we still go with 6:30, between 6:30 and 7:20? Those are my suggestions. Thank you.
Okay, thank you so much. 6:30 to 7:20, we'll take a break. And between, what is it, Adam? Was it Adam and Lebo? Who is?
No, it's Adam. But today, can I nominate Kwanele because I'm having a bit of a flu? So Kwanele Sakela, I think will assist.
It's fine, I'll assist, Judge. I'd already said I will.
Thank you, Kwanele. Thank you so much. That is appreciated.
Okay.
All right, let's start without wasting any more time. As I said, today's session is about the drafting of contracts. And as usual, South African law, anything that has to do with law in South Africa starts with the Constitution. So the first thing and the first guideline becomes the constitutionality and public policy considerations in the drafting of contracts. And I thought that is an important starting point, because then as we go along, we will have that in our minds as a guiding map. You will see that in the slides, I'm saying the public policy is to be determined with reference to the Constitution of the Republic. And indeed, that is how it is. The proper approach to constitutional challenges is to determine whether the term in a contract that is being challenged is contrary to public policy. If the term is contrary to public policy, it will definitely violate the Constitution. Or if it violates the Constitution, it will be contrary to public policy. And that's unenforceable because public policy in South Africa is gleaned from the Constitution. So I thought that's a foundation that we need to put into our heads and have it as our light going forward. And once again, Section 34 comes into play. Section 34, I'm not going to start with other sections. I'm going to start with section 34 because I would like to discuss the case that is in point with regard to section 34. Section 34 provides, it's written over there, every word, everyone has the right to have any disputes that can be resolved by the application of law decided in a fair public hearing before a court or where appropriate, another independent and impartial tribunal or forum. Now, this provision, as you will see, it doesn't just reflect the foundational values that underlie the Constitution, but it also reflects public policy. I'm sure you have heard of people, people that are accused of any number of things. You've had people even in the media saying, "I want my day in court," and that saying, "I want my day in court," means I want to be heard. I've got something to say. I've got an answer to what you are accusing me of. And my answer will exonerate me. If it will not exonerate me, there is a reason for what you are accusing me of. So before you conclude, and in South Africa, it has become quite a constant thing that the media and the public as such make conclusions, draw conclusions, and then that's not abnormal, and it's not only South Africa that does that. I think everywhere where you have human beings that have got independent minds and that can apply their minds to events and to things that are imputed onto certain, especially those people that are in the public eye. People are going to draw their own conclusions. People are going to deal with the matter. People are going to there is going to be a court or a tribunal that is made up of us, just us, the populace. So clearly, this provision, it reflects public policy because it protects the right to be heard before you all send me to the gallows. By sending to the gallows, I'm saying that very lightly. I'm not talking about the gallows. Some of you will know what the gallows are. And in the case of Barkhuizen versus Napier, which is a case that is reported in 2007, volume 5 of South African Law Reports, at page 323, the dispute arose over a contractual term, which was a time limitation clause, right? The two, between the two, the one was an insurer and the other one was an insured. And the insured, one of the terms in the contract, in the insurance contract, said, if I repudiate the contract as the insurer, if I repudiate the contract, you've got 90 days within which to launch legal proceedings against me. If you don't launch proceedings against me after 90 days, then you have lost, you keep quiet forever. You've lost the opportunity to redress. In court, when the insurer, when the insurer was taken to court by the insured in this matter, the insurer raised a special plea that the late institution of the action had released it from liability. In other words, the action by the insured was done after 90 days. And the insurer said, you had 90 days. Right now, you have released me from liability because you did not do what you're doing now within 90 days. The insured argued that, all right, we have this time limitation clause in our contract, but this time limitation clause is actually unconstitutional because it deprives me of my rights under Section 34 of the Constitution. It silences me when I need to speak. And the first court that the parties went to, which was the High Court, it upheld the applicant's contention. The insurer didn't give up. The insurer went to the SCA. And the insurer and the SCA found, well, held that Section 34 did not prevent time bar provisions. In other words, Section 34 was not against public policy. But the SCA said the case did not demonstrate that the clause in dispute had been entered into freely and voluntarily. So the SCA, whilst it found the clause to be within public policy, it didn't find the clause to offend or to violate public policy. But it did say that it is very likely that this clause was actually unfair in the sense that it might not have been entered into freely and voluntarily. The insured, this clause might have been imposed on the insured. The matter went to the Constitutional Court, which held that public policy permits time limitation clauses, right? Subject to consideration of reasonableness and fairness. So insofar as the question of reasonableness and fairness, the Constitutional Court agreed with the SCA that the clause, the limitation clause has got to be reasonable and it's got to be fair. However, the Constitutional Court said, I'm running ahead of you, sorry. The Constitutional Court said the right to seek judicial redress may be limited even though a clause, a limitation clause is even though a limitation clause is not against public policy, does not violate it, the right to seek judicial redress may be limited in cases where the right to seek judicial redress is prevented. You cannot seek judicial redress because there's a law that sanctions you not seeking judicial redress, but that law has got to be a law of general application. And then the limitation, your right to go to court, the limitation of that right has got to be reasonable and justifiable. That's what the Constitution said. The Constitutional Court said, sorry. However, the Constitutional Court turned around and said, let's look at this now, at this particular clause. This particular clause, it imposes a 90-day limitation clause. And the Constitutional Court says it's not manifestly unreasonable. Neither is it manifestly unfair. And contrary to what the SCA had said, that we don't know if this clause was not imposed on the insured, the Constitutional Court said there's no evidence that the contract had not been freely concluded between the parties. or that the clause was not drawn to the applicant's attention. So therefore, the enforcement of the clause would not be contrary to public policy. The other thing that defeated the insured's case is the fact that the insured did not, in quote now, did not furnish any reasons for his non-compliance with the time limitation clause. In other words, the insured did not say, look, I was hospitalized for 3 months and this limitation clause went right out of my mind because I was ill disposed, or I was traveling, or any number of things that would have constituted reasons, proper reasons for non-compliance with the time limitation clause. And therefore, the Constitutional Court was unable to find that the enforcement of the clause would be unjust to the applicant, which is the insured. Now, it's an important drafting consideration to ensure that to look at the various terms to see whether the terms that have been put in the contract could be found to be to offend public policy, could be found to be unreasonable, or to be found to be unfair. It's a very important drafting point that a drafter needs to have in their minds, especially you're going to find yourselves, and I'm sure you already do, you do that on a daily basis, you finding yourselves drafting contracts for the party that has got more muscle, more financial muscle between two parties in a contract. The party that has got more financial muscle is the party that is likely going to be examined very closely, the clauses that are in favor of that party are likely going to be examined by a court more closely to establish the constitutional validity or compliance with public policy. Okay, still staying with constitutionality and public policy considerations, let's look at section 25(1) and section 26(3) of the Bill of Rights. And if you have your constitution before you, you can look at section 26(1) and 2, which have also enjoyed a lot of judicial attention in the space of public policy considerations. These provisions have enjoyed quite a lot of exposure, judicial exposure. And I'm going to pick on rental housing, and that I picked on that because of its significance in the provision of housing in the housing market. And the legislature passed a number of pieces of legislation which had a significant effect on the common law of lease. The lease, the laws that govern lease nowadays in the today are very different from the laws that governed the law of lease back before the constitutional order, before we had the Bill of Rights and all of that. The result obviously was that a number of court cases that subjected the law in this area were heard, and they all subjected the law to considerable scrutiny for purposes of ensuring that there is compliance with public policy. One case that caught my attention is the case of Uniting Reformed Church, the Dunes, versus President of the Republic of South Africa. That is a case that is cited as 2013, Volume 5, South African Law Reports, page 205. If I can go straight to the case, to the next slide. There, the facts were briefly as follows. A church was the owner of 3 properties, and in each of these properties were located 3 public schools, which were controlled and administered by the state. Now, in 1987, back then, the church and the state concluded 3 20-year notarial agreements. Notarial agreements, for those of you that might not have come across notarial agreements, are those agreements that get registered with the deeds office. In other words, those are agreements that are, first of all, concluded and signed before a notary public, and the notary public registers those agreements with the deeds office. To quote one example, for instance, prenuptial agreements, like your in community of property marriage, or marriage out of community property, that is for a lot of parties a notarial agreement, because it's concluded before a notary public, and it is also registered with the deeds office. So these 2 parties, the church and the state, concluded these 3 20-year notarial agreements. And in each of them, there was a clause 16, which provided that at the end of 20 years, the church would transfer the properties to the state. And there was no indication of what the state would give the church upon transfer of these properties. And at the end of 20 years, indeed, the state knocked on the door of the church and demanded transfer of the properties. The matter landed in court, and the court held. And the court in this instance really intervened, did what is called an intervention into what would appear to have been the will of the contracting parties. The church held, the court held that the church had established facts which demonstrated that when the lease was concluded, the church was in a weak bargaining position than the state. The state dictated terms, and the church had no option but to agree. And for that reason, the court held that if the state, for instance, were to be allowed to enforce the clause, the church would be compelled to transfer its properties for no compensation. And this would constitute an unconstitutional deprivation as envisaged in sections 25(1), 25(2)(a) and B of the Constitution. Unconstitutional deprivation. And mind you, there was a contract, and the contract was signed by both parties. But at a point when the church had to transfer the properties, the church realized that this whole agreement was imposed upon us. We never had any choice but to just agree. The court therefore held the clause contrary to public policy and arising from the nature of a contract of lease, which is a relational contract subjected to equitable development over time. The common law applicable has been pronounced as being the most congruent with constitutional values. And remember what I was saying earlier, that the common law of lease has changed drastically. And it has actually now been seen by some jurists and writers as the most congruent with constitutional values and with public policy values in South Africa. It has managed a healthy and fair balance between the rights and interests of lessors and lessees. We're now talking, mind you, we're talking about the law. We're not talking about what actually happens. What actually happens is something else, and we are not, that's not our order of the day today. Moving away from the constitutionalities and the public policy compliance, let's look at certain formalities that are required in certain contracts and certain acts that serve to legalize a particular contract. In other words, any particular contract is required to be in a particular format. If it's not in that format, then it's not legal. The first one that I thought we might want to look at is the Alienation of Land Act, which is a 1981 act. It's got rules that were enacted by Parliament, the purpose of which is to obviate uncertainty. The reason why the Parliament of South Africa decided that when you alienate land, it's got to be done in a particular way to obviate uncertainty, to deal with disputes and possible malpractices in connection with contracts relating to land. Number two, to give parties an opportunity to see in black and white the provisions of the agreement. And I can't overemphasize the importance of that. And in the modern world of electronic communications, I'm living and I'm working in that space, in that world. But it is always important for me, before I finalize any document, it's always important to me to print it, at least to print the last draft and look at it in black and white and see exactly what it says, and also have a sense of the context and have a sense of how it flows and have a sense of where it starts. There is a value. Some people are able to go ahead without that, but there are those of us, and I align myself with people that feel like that. And when you alienate land, you're selling your property. I would imagine that you would want to see in black and white exactly what it is that you have done or what you are about to do. And the formulation comes from the comments of Van Vincent J. in Van Rooyen versus Hume. Sorry, I had versus Hume twice there. Versus Hume, Melville Motos. And you will see also there's another case, Folamel versus Madison. I've cited the cases for you just to enable you to look at them on your own. But because of time, we're not able to discuss each and every case. I've kind of decided to discuss the cases that are more like on point, that deal with the issues that we want to emphasize. And the disputes that the legislature had in mind can be seen also in those two cases that I've put for you there, Ferreira versus SAPDC Trading and Fraser versus Viljoen, the disputes that can occur in the alienation of land, in alienation of land agreements. The formalization of contracts as put together by legislation, it has resulted, whilst it's a good thing to have your contract written in written form, it has also given rise to a lot of disputes arising from the technical attacks on the nature of compliance and on the said formalities. The leading one in this area being that which is contained in Section 2.1 of the Alienation of Land Act, the provision which requires a contract of alienation of land to be in writing. I will read that provision. It says, no alienation of land after the commencement of this section shall, subject to the provisions of Section 28, be of any force or effect, unless it is contained in a deed of alienation signed by the parties thereto, or by their agents acting on their written authority. To provide a proper context for you, Section 28, which is the very section we're talking about, it caters for remedies to parties who have performed partially or in full in contracts whose validity is hit by non-compliance with Section 2.1 and where rectification is not competent. In other words, where you find that a contract which was supposed to have been reduced to writing was not reduced to writing. And at a certain point where that contract is challenged, there's no opportunity to rectify what was done wrong. So Section 28 provides, it caters for remedies to those parties, that have performed partially or performed in full in contracts whose validity is hit by non-compliance with Section 2.1 and where there is no opportunity to remedy the problem. It is also a warning point that I must put out there, that there seems to be some confusion created by certain definitions in the Act, notably the definitions of contract, alienate, and drafters are advised to ensure that in defining these terms, you endeavor to state what you mean while not stepping outside of the requirements of the Act. For instance, in the Alienation of Land Act, the definition of contract and the definition of alienate are not, they don't leave you with a sense that you are talking about what you seek to talk about. So I would advise that when you draft your contracts, you define the word contract. And when you define the word contract, you say exactly what you mean. If you mean with the word contract to refer to the agreement that the parties are going to sign, then that has got to come out very clearly. And if by alienate you mean transfer, or you mean contract, because alienate is somewhere defined as the actual contract. If by alienate you mean the actual act of transfer, then that's got to come out very clearly so that there's no confusion as to what these words mean. And the definition of deed of alienation as amended in 1983 also seems to mean that the buyer and the seller may sign two different documents. And if the required terms are contained in the combined documents, the contract is valid. And I can just imagine one party signs a set of terms of a contractual set of terms, a set of contractual terms, and another party signs another set of contractual terms, and all that the Act requires is that if these two different documents have got the required terms, then the contract is valid, even though the two parties have signed two different documents. That's what the definition of deed alienation tells us. Sorry, deed of alienation, sorry. It is also to be noted that Section 2 of the Alienation of Land Act applies to all sales of land, but Section 6 applies only to installment sales of residential land. All sales of land, Section 2 applies, but Section 6 applies also only to installment sales of residential land. The two sections have differences in the amount of detail that is required in the documents, a substantial number of which is referred to below. I've picked out some of the detail that is required. In a sale of land used or intended to be used mainly for residential purposes, and where payment is to be in more than 2 installments over a period exceeding 1 year, the purchaser is entitled to choose the official language in which the contract shall be drawn up. That you will find in Section 5 of the Alienation of Land Act. In terms of Section 6(1), there is a number of documents or details which are peremptorily required to be included. In other words, you can't, you have to include them. The words used there is the word that is used is shall. Those documents shall be provided. That is Section 6(1) of the Alienation of Land Act. Most of these provisions, they are content which is normally set out in a variety of contracts of sale, but practitioners are advised to look them up and examine a contract that falls in this category to diligently ensure that all the prescribed content is included, starting from the requirement that the purchaser must be requested to choose the official language in which he or she wants the contract drawn up. In other words, in terms of Section 6, in a sale of land that is going to be used mainly for residential purposes, where payment is to be in more than 2 installments over a period exceeding 1 year, the purchaser is entitled to choose Sepedi, Xitsonga, isiXhosa, Venda, any of the official languages in South Africa. And by the way, I've wondered in my own mind, the sign language being now an official language. I've often wondered how it will feature when it comes to things like contracts, because the contract, I do believe that even though the sign language is an official language, if the Alienation of Land Act requires a contract for the alienation of land to be in writing, that contract will need to be in writing. And I don't know whether the sign language will enjoy the same rights as, sorry, am I lost?
Oh,
Yeah.
you're still here,
or
ma'am.
was
We can still hear you.
somebody unmuted?
Yeah,
Yes,
I think
you can.
someone had unmuted, ma'am, but we
Okay.
still hear you clearly.
Okay.
He
Okay.
hasn't. He works in Dubai.
Oh, okay.
Kwanele Tsindisiwe's mic is on.
Okay. I was really avoiding having this conversation with you. Remember, I wanted to call. Then I was like,
Tsindisiwe, your mic
So,
is on.
Cindy Siwe, oh my God.
Thanks,
Okay.
Kwanele.
All right. Are we in order now? Okay. So I was just sharing with you my thoughts with regard to the sign language, and its status, whether it will enjoy the same the rights and the same privileges as the other official languages. Let's move on to the next slide. The attention, please mute. The attention of practitioners is also drawn to subsection 2 and 4, which regulate what can be agreed upon with respect to the amounts of each installment payable in reduction of the purchase price and interest. That, that provision, it talks to, here we are, I have a contract with a financial institution, and the financial institution, I'm paying the financial institution every month a certain amount, a certain installment. Now, I am entitled to be advised as to, out of my installment, how much of this installment goes into paying the capital debt and how much of this installment goes into paying for the interest that I'm charged. I hope we're together on that. So that you know, as a consumer, that maybe for the first 2, 3, 4, 5 years, if we're talking about a bond, for instance, you're paying very little towards a reduction of the capital debt. You are still paying quite a lot on interest. And that being a consequence of the fact that during those early years, your interest is high because the interest is calculated on the debt and on the debt that you owe at the beginning. And at the beginning, your debt is still high. So therefore, the interest payments, the payment towards interest will obviously be higher than the payment that you are making towards the reduction of the capital debt. Those sections up there, subsections 2 and 4, they also regulate what can be agreed upon with respect to the date on which the risk and profit and loss of the land shall pass to the purchaser. What is the date on which those two important things will, with respect to the land, shall pass to me as the purchaser? And when we say profit and loss with respect to land, especially vacant land, I would imagine that we're probably talking about the equity, the rise in the market price of the land. I'm also entitled to know the latest date on which the land shall be registered in my name as the purchaser, in the event that the land is not the subject of a separate title deed at the time the contract is concluded. In other words, if the land is a title deeded in the name of my seller, of the seller that I'm dealing with, and then I'm entitled to know when the title deed will actually reflect my name. The usual is that at the end, when you finish paying off your debt, then the title deed reflects your name. But these are important considerations, because the law actually says that you are entitled to you're entitled to these particular areas and these particular points of your contract to be pointed out to you, to be made prominent in your mind. So to talk of what normally happens is not the right thing. The next slide, again dealing with formalities required in certain contracts. Section 24 lays down the powers of the court in the event that the provisions in Section 6 are not substantially complied with. Can you see what I was saying? That even though there are certain things that are normal practice, but as a drafter, it is important to know that there are certain provisions in the Act that actually entitle the consumer to certain knowledge or to certain information. So Section 24 lays down the powers of the court, and those powers are they are quite intrusive indeed. There is a high degree of precision required in the documents, and where necessary, even the incorporation of building plans or diagrams into the contract in instances where, for instance, verbal description of premises becomes too onerous and subject to error. And if I can just make an example, there are certain premises, there are certain properties that you will find they will be labeled portion 3 of portion 20 something of the farm that. And whilst it can be written down, it can be reduced to writing as to portion 2 of portion 25 or portion 250 of the farm, this. Whilst it can be written down, to actually now identify when the day of the need to identify it, to actually identify that piece of land can be a big litigation headache, and in a lot of instances, it becomes quite difficult to identify those pieces of land without getting evidence, even though they've been described and put in writing. One very important fact to be remembered as well is that the legislature enacted the legislation to provide certainty, to prevent disputes and possible malpractices. That is why the Act says, where you believe that it might be difficult to identify this piece of land, you are at liberty to also incorporate either a building plan or a diagram into the contract, which would assist with the identification of the piece of land that is the subject of the contract. And that shows the legislature's intention to provide certainty and to prevent disputes and possible malpractices. Most common malpractices that have been seen in practice are perjury and fraud. Quite a substantial number of cases exist to be studied by practitioners where it will become evident that in most cases the disputes arise with respect to the identification of the physical property sold, and the contract is used for such identification. Remember what I was saying earlier, that it becomes sometimes a serious litigation issue to identify physically the property sold and the property that is a subject matter of an action without external evidence, without somebody giving evidence. And you'll find that a lot of disputes arise because of that, because of the fact that it is a challenge to physically identify property sold. And that's why the law allows even the incorporation of diagrams, incorporation of building plans for purposes of making sure that, or at least of assisting the physical identification of the pieces of property. Case law has made it very clear that in a lot of instances, the contract is not sufficient for such identification without evidence. You will pardon that typo there. Without should be together and not with and out on its own. I'm looking at the time and I see that it's almost 6:30. If I start another slide, I'm likely not to finish it before we get our break at 6:30. Are we agreeable to break now?
Yes, we are, Judge.
Okay, thank you. Then I'm going to mute myself until 7:20.
Thank you.
I'm here. Just give me a moment. No, we've got to talk now.
Judge, you're not on mute.
You're not unmuted, Judge.
Yes, I'm looking to mute myself just now.
Sorry, how long's the break?
It's until 7:20.
Okay, thanks, Judge.
Okay. What happened here? Imantombi, let me. Just give me a moment.
Zukiswa, just mute everyone so that the judge can be muted.
see what's going on with this computer. Okay. It's 22.
We are ready?
Are we all back?
Yes, Judge.
Yes, ma'am.
Yes.
Okay, good. Thank you. Let's start. Let's pick up where we left off. We left off in slide 15. Slide 15, still talking about formalities required in certain contracts and the legalization thereof. the legalization is the legalization of the contract. In the Alienation of Land Act, Section 15 lists certain forms of terms that may not be included in an installment sale contract for the purchase of residential land.
Caroline.
Where's our mute marshal? Okay. Kindly mute, please. Everybody. If one looks at the list that the list of terms that are referred to in Section 15, one sees that they have features that would disadvantage the purchaser, and it therefore appears that the rejection of such terms is intended for the purchaser's protection. You will see if you go through Section 15.1 of the Alienation of Land Act, it clearly rejects certain terms that are potentially harmful to the purchaser. Okay. I now would like to move on to another section, a section which deals with the effects of some pieces of legislation. And I've listed the ones that I'm going to deal with. The first one is the Consumer Protection Act. The National Credit Act is not part of the ones I'm dealing with today, but it was intended to be. And as I recall, I've dealt with the Consumer Protection Act and the Electronic Transactions and Communications legislation in the effects thereof in the drafting of contracts nowadays. The first one being the Consumer Protection Act, and its significance is most visible in the law of sale. It was promulgated to promote a culture of consumer rights and responsibilities. It applies to every transaction for the supply of goods and services within South Africa. It prohibits terms that are unfairly discriminatory under Section 9 of the Constitution or Chapter 2 of the Promotion of Equality and Prevention of Unfair Discrimination Act, what they call PEPUDA. It also, in order to achieve the above, Section 8.2 of the CPA identifies specific rights to equal treatment that becomes visible in the terms and the enforcement and other related factors that taint a contract of sale. It identifies specific rights to equal treatment which become visible in the terms, in the enforcement and other related factors which taint a contract of sale. And subsection 2 again provides that a supplier may not treat any consumer on a discriminatory basis when selecting, preparing, packaging, or delivering any goods for or to the consumer or providing any services to the consumer. I thought in this instance, I would like to actually list these instances where subsection 2 totally rejects. When assessing or requiring compliance by the person with the terms of a transaction or agreement, when exercising any right of the supplier under a transaction or agreement in terms of this act or applicable provincial consumer legislation, when determining whether to continue, enforce, seek judgment in respect of or terminate a transaction or agreement, or determining whether to report or reporting any personal information of such person. You will see I started from E, and the reason was that I just wanted to highlight these particular areas or activities that subsection 2 is totally unhappy with, or seeks to control or regulate. One second, let me just find where I am. Okay. And then the consumer protection legislation allows for something called cooling off. And it is a right, it is not a right that is applicable to all consumer sale customers. It is only to sale contracts to which the act is applicable and concluded after direct marketing.
Palisa, please.
Sorry, Judge, can you please just repeat
Palisa, can you?
the part about protection law?
So cooling off applies to sale contracts to which the act applies, and which sale contracts were concluded after direct marketing. And cooling off is also incorporates cancellation without reason or penalty. Who is not muted?
Palisa.
Palisa, please mute yourself. Otherwise, I'm going to have to ask Zukiswa to take you out of the meeting. Palisa. Does anyone have Palisa's number? Anyone who's got Palisa's number, please call and ask her to mute herself. Because now this is interfering also with our time.
Can we not ask Zukiswa to Zukiswa, please can you mute Palisa?
Oh. Zukiswa, are you in the meeting?
Zukiswa, remove
Yes,
her from
I
the
am.
group, please.
Please, can you mute Palisa? Well, unable Are you able to mute her?
I'm trying to.
Thank you.
Have you muted her?
Yes.
Okay, thanks. Please watch out, Zukiswa, for all these people that somehow just don't mute themselves. And it is also discouraging because I start to ask myself, how are they attending in the session if there's noise in the background? But then that's their business. But it shouldn't affect everybody else. So I was just saying that cooling off includes cancellation without reason or penalty. In other words, as a purchaser, you can cancel without reason, without providing a reason or penalty. But remember, it's got to be a sale contract to which you ended up, after direct marketing. notice to supplier in writing. Some you can give a notice to cancel to the supplier within 5 days of the letter of, all of this you've got to do within 5 days of the letter of the date when either the goods were delivered or the transaction was entered into. In other words, the later date between, if you calculate 5 days from when the goods were delivered, how long, which one is longer? And between that, and if you calculate 5 days from the date of transaction, of entering into the transaction. This right, the cooling off right, is actually required to be prominented in direct marketing material. And if sale is executed by way of transaction or contract, it needs to be reflected as a term of the contract. That is my proposition, that it's a right that needs to be prominented to purchasers, so that they know that they've got this right if they entered into a purchase transaction responding to direct marketing. The next slide, once again, is on the consumer protection legislation, where a sale is concluded via a written contract, whether as required by law or by agreement between the parties. The consumer is to be provided with a copy that complies with plain language requirements as set out in sections 22, in section 22, subsections 1 and 2. You're going to hear a lot from, at least from me, and I'm sure from other people, about writing in plain language. When you draft contracts, you draft agreements, you draft a letter, you draft anything for a client, it's always better to use plain, simple language and not legalese. For instance, let me give you an example. One will say, when they write sophisticated language, they will say notwithstanding. Whereas what you really might want to do, you might want to say in spite of. Because notwithstanding, yes, to us lawyers, you are used to what the term notwithstanding means, but the contract that you're drafting, you're not drafting for your consumption or for your benefit. You're drafting the contract for the consumption and for the benefit of the parties. It is the parties that must understand the contract, that must interact with the contract. And suppliers and lawyers need to take account of the requirements of the 2 subsections in section 22, given that lawyers are famous for using legalese when they draft, when they write. And then section 49 of the Consumer Protection Act requires of the supplier to provide notice to the consumer of any agreement that will expose the consumer to risk, impose obligations on the consumer which indemnify the supplier or any other person, or the acknowledgement of any fact by the consumer. That it's important for the supplier to alert the consumer at any stage when the consumer is on the brink of doing something detrimental or not doing something which the omission of which will be detrimental to the consumer. Those notices that are given to the consumer by the supplier, they need to be in plain language as envisaged in subsections 1 and 2 of section 22. Section 49.2 has similar provisions which enlist the supplier to draw the notice of the consumer to any prejudice that may befall it without its awareness. We're still talking about the Consumer Protection Act. Section 52 of the Act grants the courts powers to ensure fair and just conduct, terms and conditions towards a consumer in any proceedings before a court. In other words, it's Section 52 will grant the court, in terms of the Consumer Protection Act, will grant the court powers to ensure fair and just conduct, and fair and just terms, and fair and just conditions towards a consumer in any proceedings before the court. Section 51 enlists the supplier again not to make a transaction or agreement subject to any terms or condition if its general purpose or effect is to defeat the purposes and policy of the Consumer Protection Act, or to expose the consumer to any form of prejudice, risk, fraud, or any form of harm. As you can see, the Consumer Protection Act was focused at a specific particular focus in the protection of the consumer in terms of interaction with the commercial world. The next act that I thought would be interesting for you for us to look at the effects thereof is the Electronic Transactions and Communications legislation in the drafting of contracts. This is Act 25 of 2002. It was enacted to enable and facilitate electronic communications and transactions in the public interest. Its full objects are provided for in Section 2 of the Act. Part of the Act is about electronic transactions, and these are very rife in the modern era. And there are numerous platforms on which electronic transactions are concluded. I mean, I don't know, the list is just long. Electronic transactions can be concluded via email. Those are still very simple, very easy, very usual and user-friendly. Electronic transactions can be concluded via data platforms that interact with on the basis of data, that use data as language. All those platforms and some of the electronic transactions that are concluded via data, via kind of data language. Some of them are legalized via methods, for instance, I have it somewhere here in my notes. The encryption method of legalizing or of legitimizing or of signing for a contract. It's an accredited encryption device which is obtained via application for it from the South African accreditation. I think it's the South African Accreditation Institute or something like that. I've got it somewhere in my notes. We will see it just now. And the act is really not, its purpose is not to change the method of transaction. It's more the medium of communication and the evidence of the transaction that are different. So you will find that all the laws that are applicable to that particular transaction will be abided with, will be complied with, but it's the method is a medium of communication that is different, and the evidence that is a memorial of the transaction that are different. And proof of the act, sorry, not proof. Chapters, there's 2 chapters in the act that one must be aware of, and it's chapter 3 and chapter 7. Those 2 chapters, they establish certain legal requirements for data messaging, and these include contracts. The act confirms the validity of a contract that exists in a data format. It legitimizes transactions entered into by electronic agents, namely a computer server which generates an automatic message of acceptance in response to a purchaser's electronic offer. There are some exceptions, of course, and one of those, as you can imagine, will be the alienation of land. The alienation of land, I don't think the law will allow for the alienation of land to be concluded via, excuse me, via automatic messaging and automatic acceptance and having purchasers putting their offers electronically. The Act makes it possible for contracts to be in writing if the available data, if the contract is available in data message form. So you can actually reduce the contract in writing if the contract is available in data message form. Act further makes it possible for contracts to be validly signed using reliable electronic method of indicating signature. A reliable electronic method of it. A lot of people out there, especially with remote working conditions, a lot of people have had to develop electronic signatures and store them and be able to sign documents away from site and sign the document and convert it to PDF so that nobody adds anything to it, and then send it to where it's supposed to go. However, there is an exception where the signature is required by law. You are required not to sign in the usual way. You are required to use what is called an advanced electronic signature, where the signing is produced via a form of an accredited encryption device. This is what I was talking about earlier. An accredited encryption device, which the users thereof, they can only get from the South African Accreditation Authority. You will see that in the next slide where I talk about Chapter 7 of the Act. Chapter 7 of the Act provides consumer protection mechanisms which are applicable to electronic contracts. It's very important to note that, because the fact that the contract is electronic and people can do click this, click that, put your face on, face recognition and all that. The fact that all of that is in place does not mean that the Consumer Protection Act does not apply. The Act has got certain protection mechanisms that are applicable to electronic contracts. This chapter requires a large amount of information to be made available on website in which consumers are exposed to suppliers' goods. In other words, you as a supplier, if you trade with your customers, you trade via electronic means, and your goods or whatever it is that you are selling is available on a website, the Chapter 7 requires a large amount of information for you to make available all of that information in that website, which I think obviously is intended to ensure that consumers have it and are exposed to it and can use it and can apply their minds to it, can make the decision. Making the decision to purchase requires you to have information to know what it is that you are purchasing or what it is that you are thinking of doing, or what it is and why. If you want to cancel, for instance, a purchase, you need to know why you want to cancel. You need to have some level of understanding, not because you are required if you are canceling within the cooling off period, which that comment takes me neatly to the next bullet, which says the Act also provides for cooling off periods with respect to sales on electronic platform. This is now the ECTA, the electronic transactions, ETCA, Electronic Transaction and Communications Act. For accredited encryption devices, the supplier must apply to the South African Accreditation Authority. I've already alluded to that, and I think that on its own, tells us how seriously this form of contracting is taken, because of the risks that are prevalent in this kind of contracting. I had intended to include the National Credit Act in the drafting of contracts. You will recall that I had said right at the beginning that I've not included it. I'm going to have it, discuss it with you tomorrow. So I think we've come to the end of the material prepared for today. And I think we've got quite a lot of time for discussion and we actually have more than an hour for discussion and for questions. Correct? Hello?
Yes, Judge, thank you.
Correct.
Okay. Let me go to the I see a hand there, Mangela Heaven. Is that a hand up?
Sorry, Judge, I'd raised it before. I just needed you to repeat what you said about the Consumer Protection Act, but I am covered now. Thank you.
Oh, okay. All right. Any other hand? There must be lots of hands. We've covered quite a lot of ground without any opportunity for questions. Adam?
Yes, good evening. My question is on the public policy.
Yes.
Because the formation of a public policy we understand that there is some certain steps that the government or the relevant authority need to take to implement such policy. But for example, I'll give one example of which I found it, and many scholars have identified it as a big problematic policy of which is implemented. And the majority, I can say, the majority of public participants in that policy were not satisfied. Like you look at the implementation of reconstruction and development program, of which it was in favor of the liberal macroeconomic policy, of which currently is known as a growth, employment, and redistribution. It's become that policy on its own. The adoption of that policy, it was actually a problematic of which it didn't sit well, as it resulted in a lack of a democratic interaction and consultation. So my question is, how?
Sorry, Adam, you mean, which policy do you mean? You mean the gear policy?
Yes, the gear policy.
Oh, okay.
Yes. So as I'm saying that it
Yes.
resulted as a lack of democratic interaction and consultation in a public space. So my question is, how do we deal with such policies which is implemented and most public feels it was not fair and it doesn't address their current needs? For example, if I'm not mistaken, we once had this challenge of a land policy whereby I think one might say that policy has been amended or adopted or implemented as a public policy, but it still has a lot of unsatisfaction of a public in terms of consultation. So how do we deal with it in terms of as in legal space?
You know, Adam, when I'm thinking now, when a particular piece of legislation is developed, there's first I think there's first a green paper, and then follows a white paper, and then follows maybe a draft statute, a draft of the statute that is being that is under consideration, and then there's advice to public interaction. Literally, you can actually go and go to Cape Town to I'm not sure as an individual you can actually go, but I know that even as an individual you can write and put your views on paper with respect to that particular piece of legislation or to that particular policy discussion. And just to come back to gear, as I recall, that was called the Growth, Employment and Redistribution Policy. And what I remember of it was that it was supposed to focus on privatization and the removal of exchange controls, and it had some other goals that were intended to enhance economic progress in South Africa. And there were also monetary policies that went with gear, and as I say, exchange control was one of them. There wasn't total removal of exchange controls, but there were. You will recall that there were changes to certain to certain amounts of money that one can trade with outside South Africa or can carry outside to other jurisdictions, without having to make onerous applications and all of that. I don't, you see, gear, I must be honest, I don't have in my head anything that I can point out that I would say was achieved by gear. But I think the protagonists of gear will say to you there were certain economic strides that were made during gear. I'm not able to point to any. And I don't know, there's also, there will also be arguments that will say, for instance, the state-owned entities. The state-owned entities gained some ground and where there was an introduction and an infusion of some way of how things are done in the private sector into the state-owned entities. I have a difference of opinion. I am not sure. I think that the opportunities were there, and I think there was a way in which gear could have been taken advantage of, and I don't know if as South Africans we did take advantage of gear in the way that it may have been intended. Your question is, how does one deal? How do we as a populace deal with those kinds of policies that loom up, that come up, and my answer to you is not really an answer. I would say one has got to take account of a couple of things. These policies, there are policies that are constitutionally driven, right? And then there are policies that are driven by various ministries, let me say, by various ministries, and being driven by various ministries, they will also obviously be driven by various personalities in those ministries, and also by various personalities in the private sector who are in one way or another in participants or involved or affected or advantaged or disadvantaged, by those policies. I mean, and when that happens, you then have a mix of interests, and the mix of interests may not necessarily yield the results that South Africa as a country needs, and may in certain instances yield those results, but they may need to be propelled forward, to be pushed forward, to be developed further. And then we obviously operate in a democracy where there is change, forever change, you know, circulation and change of ideas coming out of various personalities that take certain positions and all that, and you're not going to be able to see the beginning and the end, or the beginning and the progress of a particular policy where I come with my own ideas, and I think as South Africans we still haven't gotten the hang of it, the hang of saying, if I come in as a leader in a particular space, let me look at the policies that were in place, that are in place, or that were being developed, or that were in discussion for the benefit of the country, and all that, and let me see which of those policies I can move forward with, and not come and change everything. I think it's a bit of a problem, because some policies may very well, and some of them, even those that were not so good, but in the interest of asking yourself, how do I take what has already happened, what is on the ground? Surely some work has happened. Some taxpayers' money has gone into a particular policy, into promoting certain projects in support of a particular policy. How can we deal with this, with what has already been done, and turn it around if we believe is not quite what we need as a country, but work on what has already happened, instead of putting in other words, throwing the whole house down and wanting to build another house. I don't know if I'm answering you, but I think your question is very difficult to answer, because it requires a commonality of mind, and it requires a meeting of the minds, and I'm not sure, you know, from a policy perspective, whether the minds always meet, and whether where the minds have met, there is progress that pushes the point that was approved by the minds that did meet. If you hear what I'm saying. Is there anyone else who would like to comment on Adam's question, or Adam, would you like to comment further?
Now, let me firstly give colleagues opportunity as well.
It's a tough one, Adam.
Yeah, indeed, acting judge, because one other thing that I've looked at in terms of policies is that a policy is being implemented. Let's say, let's give a scenario of a policy that implemented in 1980. And now we are in 2023, whereby a lot of scholars has done multiple research in challenging or in looking at that particular policy. But it seems as whenever the government or whoever in the implementation of policies does not consider that scholar or the report that is being, for example, being implemented. So some of the policies that have been implemented, whoever is in charge tend to ignore some of those things. Like a certain policy that is implemented in labor, whereby I remember I just forgot to ask the other day when we were doing the dispute resolution.
Yes.
Yes. But you find one is been on a precautionary suspension for over 2 years with full pay, with full benefits, and one is acting on that position. Meanwhile, the other colleague is on suspension. So you look at how the taxpayers' money is being misused. So due to, we still stick on that policy that has been implemented in 1981, of which now we're in 2023, whereby even the CCMA or the labor policies, it says it should be 60 days or so. So, but now we turn a blind eye because we said, no, want to get rid of this one and want to focus on this one. And because of the same policy that is implemented in 1980, we're still applying it even today. So that's my challenge. So to say, why, if maybe the policy has been implemented, not only to look at the public participation or consultation, but to also to look at the scholars on what the scholars says about this particular kind of policy related. So yeah, but I get your point, what you're saying. It's a difficult one indeed.
Yeah, and also we must be careful. We must stay within contract drafting. We must try to. I know that once things start getting into things like policies and stuff, it all becomes interesting because it gets thrown into a wider space. But let's try and stick to policies that affect the drafting of contracts. Although the policy that you're talking about, for instance, with respect to suspensions and all that, is on point because it would come up in a discussion of a labor contract, for instance. I'm thinking, and I think let's also try and look at the various pieces of legislation that have been promulgated to push certain policies, and there's been a lot of those. I see a hand. The initials are CS. I don't know if
It's
Good
Caroline.
evening, ma'am. Yes, it's
Sorry?
Caroline. Good evening, ma'am.
Oh,
I would like to say I
yes.
share the same sentiments with my fellow student. However, I would have thought that we shouldn't be politicizing the lecture. However,
Yes.
we also do have a platform where we can challenge the illegitimacy of any legislation, that is the judiciary
Yes.
or either. But I would think that he has a valid points, but now it has become a political concern rather than a legal concern. That's my 2 cents worth of opinion.
Thank you, Caroline. That's why I was saying earlier, if you heard me, let's try and stick to contract drafting, because if we allow ourselves, which is very easy, because we live in challenging times, even politically. So it's very easy to find yourselves sliding into a politicization of a discussion. But we are going to have to rein ourselves in and stay within the topic that we are about, and discuss policies to the extent that we talk policies. We discuss policies to the extent that they have given rise to certain, because the pieces of legislation that I discussed, they are pieces of legislation that were promulgated in order to give life to certain policies, and those policies are there. I mean, for instance, the policy that sought to protect consumers, the policy that seeks to electronify our transactions and our communications, especially because of the what shall I say, the incorporation of South Africa into the world space, into the global space, and how we are in a space where we need to be able, we need to be able to transact wherever you may be. We need to be able to legitimize your transactions wherever you may be, and not be stopped by borders and all that, for purposes of doing trade. It's particularly important in a growing democracy like this one to be able to trade freely as much as possible, and to open up, to open ourselves to the world for trade purposes, and to invite the world into our trading spaces, to invite investments into our space. So the electronification, that act, this Electronic Communications and Transactions Act, is one of those pieces of legislation that seek to achieve that, to achieve to support those kinds of policies. The CPA is a piece of legislation that supports the protection of the consumer as a policy. So I would like for our discussions to go in that direction, in the direction of discussing the policies and the intentions of the policies of the policymakers in promulgating and putting into place the particular pieces of legislation that were intended to support those policies. I hope we are together. Anyone wants to make a comment?
Yes, Judge, I do have a question, but from a practicality perspective, and it just hovers around the issue of reasonableness. I'm not fully appraised on the facts of the case, Buckhazen versus Napier, but I just want to understand what steps should one be thinking of when they are drafting a contract and they do not want to be caught with their pants down on this issue of reasonableness? Because certain things are very easy. You can pick up case law, you can pick up certain sections of the Constitution and other legislation to figure out if what you are doing is fair and if it's legal and all of that, and if it's constitutional. But this issue of reasonableness, and I think I also struggled with it in varsity when I was doing my undergrad. It seems like mystic arts for me from a practicality perspective. And I just hope that you can take us through what are the steps that one should be thinking of to get to a point where they say this legally binding contract is also reasonable for whatever purpose that contract is for. I hope I'm clear.
Yes, I understand you. Let me talk about when I address reasonableness. Let me talk about the bonus paterfamilias, right? The reasonable person. When you are discussing reasonableness, you have to, because what kind of a term is it? When you're discussing reasonableness, you've got to ask yourself, a reasonable person, what would a reasonable person in my profession, or who's got the knowledge that I have, what would that reasonable person think of this term in a contract? In that case, Buckhazen versus Napier, the thing about it was it reasonable to have a time limitation clause to start off with? Because I think Napier was arguing that the time limitation clause itself is unconstitutional and therefore is against public policy, because it silences me, it robs me of the right to be heard. Because it says if I miss 90 days, I have lost my right to be heard. Now, the question is it reasonable to have that kind of clause? And one must ask themselves, would it be reasonable to have anybody or somebody, if you are in trade, you are a supplier of something, you are a seller of insurance and all that, would it be reasonable to be exposed to liability for life, to possible liability for life? Would it be reasonable that out there's any number of people that can sue you for any number of repudiations that you have made, and that right goes into perpetuity? Would it be reasonable? Would that be reasonable? And the answer is immediately no. you can't have that kind of state of affairs in perpetuity. There's got to be a point where it is lost. It's the same like prescription. What was an operation there in Buckhazen versus Napier was prescription. A debt, if I know that so-and-so owes me money, and the due date for X to pay me that money is the 4th of July. That's the due date. And I don't send anything to X. I sit and 3 years goes by. And after 3 years, I decide I hit bad times and I decide, whoo, X owed me money that was due back in 2023. On the 4th of July, X was supposed to have paid me. And in 2027, I then decide I must go after X for that money. The question is that reasonable? Is it reasonable to have any number of people that have got a Damocles sword, the various Damocles swords that are hanging over you in perpetuity? And I have to say outright that even to me, not being a scholar, even to me, just as an ordinary person, that doesn't sound reasonable. There has to be a time when whatever indebtedness I have comes to an end. If the person that I owe money to does not ask for it, does not come forward, does not activate me to pay, then at a certain point they must lose that right to come after me. Because otherwise, think about it. Just to put the whole thing on in a ridiculous space. If in 2027 there are 10 people that remember that you are supposed to pay them in 2023, and they come after you, where would that take us? That wouldn't take us anywhere reasonable. It wouldn't be a reasonable space at all. So I don't know if I have described reasonableness to you, but what I'm saying, what I've said, I'm trying to say is that it's something that one needs to ask the question: is it reasonable? Is it the sort of thing that you want to see? Is it the sort of thing that you can live with? Is it the kind of world you want to be in? And that then obviously develops into a policy, and a policy will give birth to pieces of legislation that are enacted to support that policy. Are you with me?
Yes, my lady, I'm with you. I think what I'm getting is there's a question that I should be asking after having considered everything and ask, what if another 100 people did exactly the same thing? Would that result into a society that makes sense and a society that we are able to live with? And if the answer is no to that, then that particular action should be considered unreasonable. I think from a, and I'm sorry to reduce so much of the knowledge that you've given me into a short paragraph, but for me it was all about how do I make this practical in my mind. But I think in my mind it says that if there's a certain situation that is occurring in front of me, and I'm asking myself, what if other 100 people or another 1,000 people did exactly the same thing? Does that yield a society that I'm happy to live with? And if my answer is no to that question, then perhaps that particular action or decision or whatever is not reasonable.
Or term of a contract is not reasonable.
There you
Because
go.
you know it would be in the context of our discussion, it would be a term of a contract. Sorry, Cora, I can see your hand. I don't know how long you've had it up, but
It's
now I can
Quintus
see.
first. It's
Sorry.
Quintus first. Then it's Quintus first. Then Cora next.
Oh, okay. Sorry.
No problem, ma'am. But just with regards to the Barkhuizen and V. Napier case, I think, on the reading of that, the court took into consideration various considerations that needed to be made. So they looked at industry standards. They tested against the limitations clause to see if it was justifiable. They also used an objective standard to assess the reasonableness, but that case fell short. And on my understanding, primarily because Napier's condemnation application was very weak. He didn't substantiate why he was out of time in raising his objection to the repudiation of the claim.
Exactly.
Yes, so those are what I took away from that case. With regards to my question is not really around policy, and you can tell me if you'll come to it at some stage during this series. I wanted to find out mainly about option agreements and whether an option agreement would be voidable for vagueness if you didn't state the purchase amount for when the option was exercised. And then also, how would one be able to escape an option agreement? So let's say I, as the seller, included an option agreement. However, by the time the option is ripe for excision or to be exercised, would I be able to escape such a clause? And if I wanted to, would there be wording that I would need to insert in the clause to allow myself the option to escape from that? Thanks, Prof.
I certainly think, in my mind, when you make an option to purchase, let's say an option to purchase shares, if you do that, I think you have to put a price to it. You without a price, it seems to me that it's a half an offer. You've got to put a price because the share is not static. If you don't put a price, you next week the share has tripled in value, or next week something has happened and that I think that by its very nature, an option to purchase has got to come with a price.
Okay.
Quintus?
Yes, ma'am. So it has, but then in a situation like where share price changes and you're not certain what the price would be at 5, could you put an estimate to say, okay, I would have at the time when the option becomes exercisable, we'd sell for the price of the share plus 10%. Would that suffice, or is it still too vague?
No, if it says the price I'm offering will be the price of the share at that stage plus 10%, then it's very clear. I don't see anything unclear about that, because there will be a price, and you are putting a percentage, a premium of 10% of the price of the share at exercise. At exercise point.
Perfect. Thank you so much, ma'am. And then to escape an option agreement, if I wanted to be able to, how would I go about doing that?
If you want to escape the option agreement.
Yes. So if you and I have an agreement, and you have option to purchase, let's say the land. So like I was looking at Van Aert v Galway, that case, where clearly you could see that the seller didn't want to honor the option agreement anymore, but I couldn't see any way for the seller to negate or back away from that agreement. How in practice?
But that's probably because they didn't put an exit clause.
Okay, so I'd escape it with an exit clause.
Because I think you need to have an exit clause if you for you to protect yourself, and your exit clause might be something like if the price of the share goes up, especially in the instance that we're talking now, you're saying the price of the share plus 10%. You might want to have an exit clause that says if the price of the share goes up to more than 20% of what it is today, then I would not exercise this option.
Thank you, ma'am.
I would imagine that is quite important, because otherwise it means you are tied up in an option where you are grossly disadvantaged. There was Cora, and there's now Sindisiwe, but let's start with Cora.
Good afternoon, ma'am. I wanted to add on to what you previously said, but I think my question is now lost in the moment. I just want to withdraw my question. I hope you don't mind. Thank you.
No, not at all. Not at all. If your question has either been answered or maybe dealt with in the conversation, then that's understandable.
Thank you, ma'am.
Hi, Judge. So in terms of, so the cheapest option would to ensure that in all contracts there's an exit clause that will give you an opportunity to be able to leave the contract if you feel as though there's certain aspects that will not be met, or if you feel as though you want to then come out of it. So if you don't have this exit clause, and you later find out that the contract in which you got involved in has specific aspects of it that are unconstitutional, that's the more expensive route to go, because it would take years before a court has set it aside, right?
You can approach the court on an urgent basis. And if you feel you can argue urgency and obviously financial urgency, potential financial loss is qualifies it usually qualifies for urgency. You can approach the court on an urgent basis and seek redress, seek a remedy.
Okay.
Yeah. Was there someone else? Doesn't look like there was anybody else. Is there anyone else that has got a question or a comment or a point to discuss? That means we can finish some 30 minutes earlier.
Ma'am,
And I don't think we can be punished for that, can we?
No,
Ma'am,
ma'am.
Not at all.
You're the judge, my lady.
No, not in this instance. Was there someone who was trying to say something? No. Okay. I think we have a reprieve. We have a 30 minutes reprieve. And it might be
Thank you.
good to take it. Thanks
No
to all of
objection,
you
Your
very
Honor.
much. Thanks
Thank
so
you.
much to all of you.
Thank you.
Thanks so much.
Thank you.
Bye,
Thank you.
everyone.
Have a good night.
Bye, Judge.
Bye-bye.
Thanks, Judge. Bye.
Thank you, everyone. Bye.
Bye.